Hi friends, I'm Chelsea Grayson coming to you once again from the Office of the CEO. This is my show where I can help you be more successful in your current career, and I can also help you successfully transition to a new career. So today I'm going to give you the last part of my ongoing series about how to understand a legal agreement so that even to the extent that you've got a lawyer and you're not the lawyer on the deal, you're just a party to the transaction, you can always be certain that you've understood the legal contract perfectly memorializes the transaction that you thought you were entering into. Because, listen, at the end of the day, you're the one that's going to have to live with the deal that got done, not the lawyers. They get the deal done and they walk away, and then you're stuck with the document that governs your relationship with the other party or parties to the deal for the entirety of that relationship. So that's actually a fundamental point that I wanted to drive home for you guys, that the legal agreement is being written for several purposes, right? It's being written to govern your relationship with the other party or parties to the agreement. If you're just selling your company or if you're buying your company, that might be a relatively quick relationship after you guys have entered into the legal agreement. If you guys are doing a strategic alliance or some kind of a joint venture, a distribution agreement, a licensing arrangement, some sort of a collaboration, that might be a transaction that has a life of its own for many, many, many years. The parties to the transaction are going to be obligated to do certain things over the course of that relationship. They'll be prohibited from doing certain things. There will be money that exchanges hands. There might be disputes that have to be mediated. And you want that document to perfectly set forth all of the rules that govern that relationship. So first, you're drafting that agreement for the parties to be able to go back to periodically, to look at and say with certainty, this is what this means. This is what I need to do in this situation. This is what they're not supposed to be doing, and I can call them on it, and here's my remedy, et cetera, right? So that's thing one. Thing two is the worst case scenario. This is when there is a dispute, when the parties have a disagreement over something. Maybe they want to terminate the relationship, and it's a particularly acrimonious termination of the relationship. This is when you're going to have to be certain that your agreement says what you want it to say, because a third party adjudicator, whether it's a mediator, an arbitrator, a judge, maybe it's all three, maybe it's a panel, somebody else, some neutral third party is going to come in, read and interpret the agreement, and it's going to make a judgment one way or the other. This party is right, this party's wrong, or maybe it's a little bit in between. And they are going to be determining the fate of how you come out of that dispute. That is why it is so critical to be super clear when you're drafting these agreements, and to be super clear that you understand each and every provision before you sign your name on the dotted line. So I wanted to quickly give you my 10-point agreement review checklist. And this doesn't discount all of the advice that I've given you in the previous episodes. That is the real meat and potatoes of the way that you need to look at each specific provision. But this is just sort of a quick checklist that you can go over before you execute a document, just to make sure that you've read all of the provisions correctly and you're thinking about all of the right things, and there's no more questions you need to ask before you enter into this agreement. So number one, look at all the particulars. Are they all right? Again, are the parties listed correctly in the document? Do there need to be other parties that are obligated to do things or prohibited from doing things that need to be in the agreement or maybe inside agreements? Are there parties in the agreement that shouldn't be in there at all because they're not obligated to do anything and they're just beneficiaries of the agreement, so they should be taken out altogether and shouldn't have to sign anything? Are the parties accurate in the agreement? Do you have the dates correct? Is the date of the agreement right? Is the date of the closing correct? Are the dates of the various obligations of the parties listed correctly? The last thing you want is the wrong date and somebody's able to escape a particular thing they had to do because the date was wrong. Are the dollar amounts right? Obviously, this is super critical. Nothing else needs to be said there. Make sure everywhere you see dollars or currency listed that it's accurate. Is it the appropriate structure? Number two, is it the appropriate structure? Did you think you were selling some assets or a division, but instead you're ending up selling all of the stock of your company? Worst case scenario, right? Did you want to do an asset deal, but it's a stock deal and that's not going to be beneficial to you from a tax perspective? Did you think that you were doing a strategic alliance, but all that's really happening here is a licensing arrangement? Just make sure the structure of the agreement is proper, and make sure that if there needs to be other side transactions, that you've memorialized those in side agreements. 3, is there clarity of performance? Is it clear what each of the mandatory obligations for each of the parties are? And is it clear what their rights are under the agreement? What may they do and what shall they do? Big distinction there. We've talked about it in previous episodes. Make sure that's all very clear. Number 4, reps and warranties. We've talked about these ad nauseum, right? This is the risk shifting burden. This is where one party is saying, this is the state of things as they currently are, except to the extent that I've listed a disclosure on the disclosure schedules, and the other party gets to sue them for breach if they've misrepresented something or if something they've said in the representation and warranty isn't true, right? So do we have the proper scope of the representations? Are all of the right representations there? With the proper limitations, right? We talked about materiality qualifications, for example, and knowledge qualifiers in previous episodes. Do we have the proper subjects? Are these representations and warranties backed by legal opinions to the extent they need to be? And your lawyer can help you answer that question. Number 5, do we have internal and external consistency? So we've talked about defined terms, how capitalized terms in a legal agreement take on the very specific meaning that they're given in that document. So have you checked all the way through the document to make sure that all terms are properly defined and that every time they're used, it's consistent with that definition that's been ascribed to them? In a particular situation where a word has been used and you don't want it to have that defined term definition, do you need to come up with a different word to use so there's no confusion? Also, in terms of external consistency, have we made sure to incorporate all outside agreements into this document? And have we made sure to specifically say, yeah, we had this back of the napkin arrangement, we had this other agreement in place before, those have been specifically terminated, those are null and void, they have no continuing force and effect, they are superseded by this document that we're now entering into. Number 6, do you have a substantive understanding, just with a common reading of the document, do you understand the document? Does it say what you thought it should say? There might be places where you need to talk to your lawyer because there might be legal jargon that's being used, but do you generally understand what is happening in this document? Maybe give it to somebody completely on the outside that you trust, have them read through it, and then have them give you the understanding of what they think is being accomplished by this agreement. You want it to be in plain language as much as possible. Number 7, after you've read through the agreement a few times, hypothesize what performance looks like. Think through the transaction. Does the document actually work? Do all the pieces fit into place? Are the performance of the various obligations in the right order? And are they listed like that in the document? Is there a method to each of the things that has to happen? I don't want to get too deep in the weeds here, but for example, if there's a purchase price listed in the document, but that purchase price can be adjusted upward or downward post-closing because of something that is found between the parties to be different. So if you said, I have a particular dollar amount of working capital on the closing date of this purchase, you proceed to sell your company and it's determined a few weeks later that in fact you didn't have as much working capital as you said you did, is there a mechanism by which the buyer can get a refund for part of the purchase price that they paid you because you didn't deliver as much working capital throughout the course of the closing? If that's what you think is supposed to happen, or if you're supposed to, for example, get more consideration post-closing if you delivered more working capital than you said you were going to at the closing. Is there a way for calculating that? Is there a way for communicating that between the parties? Is there a way to mediate a dispute over calculation? Is there a way for you to either get money or have to refund some of the purchase price? Those minute details in terms of the way that the parties operate between each other must be set out very specifically in the document in meat and potatoes language. Hypothesize not just performance, like we just talked about, hypothesize non-performance. Assume that somebody hasn't performed this document the way they should have. Does the document work in that case? Do you have the appropriate carrots and sticks, so to speak, to protect your interests? Is there enough incentive in the document for everyone to perform? And if they don't perform, do you have enough sticks, right? Do you have enough ways to discipline or penalize a party that doesn't perform to maybe disincentivize them from non-performance, or at least to make yourself whole to the extent that they don't perform? Number 9, address what happens if one of the parties files for bankruptcy. That is a huge conversation, and I might actually do a specific episode on bankruptcy protections, but just make sure that your lawyer has addressed that to the extent you're performing this joint venture and the other party files for bankruptcy, whether it's here or in a foreign jurisdiction, you are protected to the fullest extent of the law, and you have a path forward, even though they have filed for bankruptcy, right? What if, for example, you are selling a product to a big company so that you can sell your products through their company on a wholesale basis, and they file for bankruptcy? They have your product in hand. They hadn't yet paid you. What is your recourse in that situation? Your legal agreement with that company should address that. And finally, number 10, imagine the worst case scenario. Unrestrained, overfunded litigation. Let's say it's David and Goliath. You're dealing with a Goliath and you end up in litigation with this Goliath. What's the situation there? If you win, do they have to pay your legal fees? Where is it that you're going to do this dispute? Is it going to be mediation, arbitration, a courtroom? Is it going to be by a trial by a jury, or are you waiving your rights to a jury trial? Where is it going to be? Which state is it going to be? Which laws apply? Which state laws apply, right? All of those things that we've talked about in previous episodes. Imagine the worst case scenario and think about whether or not you know what the rules are there and how covered you are, or if you're not covered, that you're just aware of the risk. So those are my final thoughts on understanding legal agreements from a layperson, non-lawyer's perspective. I'd love for you to drop comments and let me know if you've got other thoughts or other issues that you'd like for me to raise in this area. Please do subscribe to my YouTube channel so you don't miss future episodes, and I will see you next time from the Office of the CEO.